Sorry, it turned out to be quarter past.
I'm sorry, my fault.
Yes, it looks like we've got more. Thank you. We did, in the meantime, receive the practitioner comment, which I'm glad to have seen, put it that way, but I agree it doesn't really add to any reference to our authorities we anyway have. And again, passage from Clarkson, it then became clear that the passage from Charlesworth was all about Valenti, which is not relevant. But again, useful to have tracked it down. Right, so these are the maps.
These are the maps. My Lord, this one indicates the proximity of individuals that we're concerned with their premises.
Sorry, is there a copy for me?
Yes, thank you.
So quite close to each other. And then if you would go to the next one, it shows you where the Mumu's nightclub is,
Yeah.
where the scene of the accident is, and the opposite directions from their homes. And the final one, which is slightly more blown up, gives you a better perspective of where the houses are that the litigation
Well, that's all we need. That's very helpful. If there are scales on this, they're almost illegible, I think.
they are, but the judge indicates.
Oh, I see. No, I can see. It's one. As you say, the judge does actually say, but there's a 1 kilometre.
What the distance was, yes.
Well, thank you. Unless my lords have any questions about those, that's what we needed, I think.
Thank you.
Most grateful. Yes, Mr. Kennedy.
Thank you, my Lord. My Lord, I hope to divide my submissions into 4. The first part to deal with the finding that the judge makes at paragraph 60, that the claimant consented to being driven by a driver who he was aware had drunk a sufficient amount to impair his ability. The second part of my submissions will deal with criticisms of the judge's approach to the evidence. The third part will deal with the finding that the learned judge made at paragraph 68 of his judgment, that he must assess contributory negligence not subjectively, but on the basis of the reasonable man who could assess fitness to drive, and that such a man would have concluded that Dean Brown was not fit. And the final part will address contributory negligence.
You mean apportionment? You mean the figure?
The figure, yes.
Right.
I apologise, I should have said apportionment. And talking of apologies, there are 2 preliminary matters, and the first of those is a request to correct my skeleton argument. Your Lordships will know how many sifts skeleton arguments go through before they find their way to your Lordship. But as my instructions...
Depends.
Like judgments.
Yes,
When I was at the bar, I never allowed anybody to do anything to my skeleton argument. But
As my instructing solicitor was on his delayed train this morning, he rang me up and told me that in my summary at paragraph 1e, did I not mean if the law were otherwise, then as the judge observed at para 74 of his judgment, it would produce the anomalous result that in
yes,
law a mild...
should say worse.
Which it should have said worse.
Well, that's, yes, as very often happens with something like that, I read what I expected it to say.
And I did that on several occasions.
Yes. Okay, thank you.
The second preliminary part is if I could ask your Lordships to look at the supplementary bundle and just to take you to 4 bits of it so that if things go my way, I don't have to refer to it again. And the first part I would refer you to is behind tab 5. This is one of the statements of Aaron Brown. And it's page 19, paragraph 11. And it's just the description of walking from the club to the car, where Aaron says in this statement, which was, as it happens, given to the claimant solicitors, Dean and I followed them out and took hold of Liam as he couldn't stand up on his own. We walked towards the car, holding him up on each side. And what we would say about that is that implicit in that is this is assistance. He is not being carried there. He is participating in that journey. And to pick up on a point made by one of your lordships, when he got to the car, he had the presence of mind to lean out of it when he felt he needed to be sick. And there is reference, this is also in paragraph 12, to there being a conversation. Granted, only a very short conversation, but it is in there. So that's paragraphs 11 and also paragraph 12. Staying on the same page at the bottom, there is discussion of what happened once Dean and Aaron got back to the car. And in the middle of paragraph 17, Aaron makes the observation, Liam was never in a fit state to put his belt on himself or to get himself into the car on his own. He needed us to help him. And again, I make the same point that helping requires participation on the part of the person being helped. My lord, you asked my learned friend about the meaning of the word passed out and the fact that it can have a colloquial sense as well as a technical sense. And that observation is in my submission given added force by looking at page 26, which is behind T7 in the supplementary bundle. This time we're looking at the statement the defendants took from Aaron, and we're looking at paragraph 12. And there he says, about the time when they were back to the car, I can't be sure, but believe that Liam was still wearing the seatbelt. He was obviously asleep. I didn't speak to him or try to wake him up. And indeed, if you look at the description in paragraph 9 of the walk from the club to the car, what Aaron says is he was awake and conscious, but very docile. I recall he said something as we walked to Dean's car, but don't recall what he said. So it perhaps gives more of a picture and more of a flavour in relation to the evidence before the judge.
Yes. And then in para 10, he again uses the phrase fell asleep rather than passed out.
Yes. Yeah. And just whilst I have this bundle in front of your lordships, can I take your lordships to two other parts which may or may not be of interest? There is a generic picture of the car on page 69. It may be that your lordships are fully familiar with Seat Ibithas and two-door Seat Ibithas, but one is there.
69.
69.
Yes.
Finally, just so you know where the learned judge got his height and weight from, that's behind tab 12 at page 98. Under assessment, this is part of the initial assessment of the claimant. You can see the height and weight just before the second whole bunch under assessment.
And that hadn't been picked up by the experts, the seatbelt experts, until the trial, is that right?
That is right.
Sorry, I'm very old-fashioned. I'm sure everyone else in court can tell me. What is 75 kilos in?
It's a shade under 12 stone.
11 stone 8.
Thank you.
or £165.
And the height is a shade under 6 feet.
Thank you.
I think the judge translated it in his judgment. I can't.
Yes, I just didn't have it in my mind at that moment. Yeah.
So if I can then turn to the first part of my submissions, which relate to the consent finding, and here I'm beginning in terms of references to our skeleton argument, paragraph 10 of that document on page 49, where we describe the judgment.
Just to get it off my chest, another skeleton argument which nominally comes in under 25 pages but doesn't really.
I know.
Don't do it again. Right. Yes.
It was described as careful. And what we mean by that is that in our submission, the findings were the product of a careful evaluation of the evidence, which included making findings of fact and drawing reasonable inferences. And we make that submission not least because the judge reminded himself that that was what he was doing. And you can see that in the judgment behind tab 6 on page 82, paragraph 11, when he says exactly that. And there are instances of that approach in action and of the judge declining to draw inferences within the judgment itself. So if we take an illustration of the approach in action, we have that at paragraph 36 of the judgment, where the judge makes a finding, this is at page 86, that Dean assisted the claimant to the back seat. And in our submission, he did that in the light of 3 facts. First, the significant drinking which had gone on, and you can see that referred to first in the judgment in paragraph 16.
Hang on. Yep.
Second, the evidence that we've just been looking at, that the claimant had had to be assisted to be walked to the car, and that's at paragraph 17 of the judgment. And the third, the fact that he changed position. And that involved the movements which the judge went to some trouble to separate out. Paragraph 34 of the judgment, page 36. To do that, you need to undo your seatbelt, get out of the car, move the front seat forward, get into the rear seat, and close the front door.
When asking you the same questions my lord asked Mr. Ross, move the front seat forward doesn't necessarily actually shift the whole seat forward, just need to push down the back.
I can't say whether
No,
it did
I
or
agree,
didn't.
but just so we
Yes.
understand one another, the one's a bit less complicated than the other.
Yes, I would.
Can I just check, the finding as to his position after the accident was on the basis of the police report, was it?
It was on the basis not only that he was in the back seat was a matter of common ground on the basis of the police findings, to the best of my recollection. The finding as to which way round he was involved some assistance from the seatbelt experts as to whether or not his head was on the offside or the near side.
Getting into the back seat of one of those cars which you have to move forward, and I'm giving evidence now, involves usually a lever, doesn't it? A
Yes,
lever
it does.
being lifted.
Yes.
and the seat then,
Yes.
the back part of the seat, this part,
Yes.
being moved forward.
Because for obvious reasons, it has to be reasonably stable
Yes.
in normal use.
So 3 actually involves 2 actions, doesn't it?
Yes.
Probably. And we don't know we haven't really details about this, but it probably involves 2 actions: lifting a lever and pushing or pulling the seat, the back.
I would respectfully agree with that.
To answer my Lord Dingemans' question, it was also dealt with in the joint statement of the seatbelt experts.
Thank you.
Where the articulation of where he was post-accident is
Thank you.
found.
So that is why the learned judge drew the inference that the claimant needed help and that Dean gave it. And we submit that in so doing that, he asked himself the right question. To use the phrase used in the skeleton argument at paragraph 12 on page 49, we submit that the judge set himself correctly. He was aware, and if I may, I'll draw your attention to the point at which he makes this explicit. Paragraph 40 of his judgment on page 87. He was aware that there was a boundary beyond which inferences could not be drawn because the evidence was not there to justify. And he analysed his own thought processes critically. You can see that at paragraph 40. And not 2 paragraphs on, you can see him refusing to make a finding. This is at paragraph 42, because he did not consider that the evidence was there to allow him to do so with sufficient certainty.
Does it matter that he didn't consider whether anybody else was involved other than Dean?
Well, what I would say about that is no, because it is such an obvious inference to draw by reason of the time of day and the surrounding circumstances.
What?
The surrounding circumstances, it's club leaving time, there's a party of 3, Dean is one of the party of 3. You have to ask yourself on a common sense basis, would you actually have someone else go and help you? And the answer is you wouldn't.
Why put him in the back seat?
Well, that is, in my submission, that is a very good question. The reason why to put him in the back seat was, as the judge found, because there are 3 of them and they're going home.
But there's only 2.
Well, there's only 2.
We know of.
Well, there's only 2 because one of them's gone to get jumping. If this is jumping slightly ahead of myself, if I may just set out objectively what can be seen from the facts and what can reasonably be inferred at that stage. They went to the nightclub as a party of 3. It's 3 o'clock. The clubs have shut. They have come back to the car. That is, Dean and Aaron have come back to the car. The claimant has stayed there.
It's not in the car park, if there is such a thing.
No, it's
about 5 minutes away in a side street.
It's about 5 minutes away in a side street, but yes, that is correct. So they have tried to start the car. We know that as well, and your lordships may be far more organised than me and have never had the experience of trying to start a car when it will not start. But it's not a process that one tries it once and then stops. It's a process that involves increasing frustration before one tries to go and get the jump leads. So there's that. There's then, as we know from the evidence, a discussion between Aaron and Dean when Aaron says, I know somebody in the club. By this time, of course, and I've forgotten to say this, there has been the kerfuffle of Aaron getting into the back, albeit that we can assume he got into the back via the driver's door. Aaron then gets out again, so you have getting in, getting out again. And it's only then that the claimant is moved, and he's moved from a situation.
When you say only then, just to be clear about this, it is at some point in the next 25 minutes.
I accept that. But if you're asking, to go back to my Lord's question, if you're asking why do it, there's a man in the front seat. He may be asleep. He's certainly comfortable there. And again, it's a general proposition that your Lordship's entitled to take into account. One is more comfortable in the front seat than the back. That's why one gets complaints from one's adolescent children when it's their turn to go in the back. He is there, he's comfortable. Why put him in the back seat? Because Aaron's coming back, because we're going home.
But why leave Aaron behind then? Why? There's lots of questions here. Why leave Aaron behind? And how did he start the car?
Well,
in the back street in Cheltenham.
That, my lord, is not the reason why he wasn't able to start the car to start with, and why he was subsequently able to start the car is not something I can assist you with.
Was there any mechanical evidence about the car, or it had been destroyed so much?
It's been destroyed so much. There are pictures of it, my lord.
The thing about drawing inferences is you're going to draw an inference. You're going to draw inferences from the whole of the facts, from the whole of the factual analysis that you have. And if there are gaps in the facts, there's a danger that the inferences will be distorted. Isn't that right?
Well, my lord, this is where the trial judge, exploring this process carefully, in the context of a courtroom, is best placed to work out where the boundaries are. And that is what this judge did in this particular
case. So he asked himself the questions.
Yes.
How did he start the car? Why did he leave Aaron behind? Why did he drive in the direction up to Pewsdale?
And crucially, although he was aware of those questions and that he couldn't answer them, he thought he could nevertheless make inferences on the points that mattered without answering them.
Yes. That would be my submission.
Doesn't it look as though another person must have been involved here? To start the car?
My lord, no, again, perhaps I'm drawing on personal experience, but one does come across times when at first one cannot start a car and then one is subsequently able to do so.
If it was turning over, sometimes it just catches.
Yeah.
It doesn't. Very easy for us to speculate. It's perfect. Another factor is that, of course, he and Aaron were both pretty drunk, so that they may have, as it were, given up too early when Aaron went off, or been doing the wrong thing, or so. Was it manual or automatic?
I suspect it was a manual, but I don't know that for certain. It's simply the model.
But
yes.
The truth is, all we know is that they were not able, whether they should have been able, but they were not able to start. They thought they couldn't start it, and at some point subsequently, by some means, they did start it.
That is right.
Your point is, it doesn't necessarily mean that an obliging stranger or AA man came across from behind in the middle of the night and started it.
I agree. And so that, if I may, takes me back to what I submit is the simple but important finding that the judge made and that he was entitled to make, which was that the claimant was awake when he moved from the front seat to the back seat. And he weighed up the evidence that he had. That is, the judge did. The claimant weighed, I've got it down here as the thick end of 12 stone, but 11 stone 8 is not the thick end of 12 stone, it's 11.5 stone. He weighed 11.5 stone. He was nearly 6 feet tall. The process he had carefully delineated, paragraph 34 in the judgment. It is not just an inference, but I would respectfully endorse the judge's finding that he was driven to find that this is not something you could do to someone who was unaware you were doing it. Because of the nature of the manoeuvre, you need the cooperation of that person, even if they require assistance. And because you need that assistance, you can and should infer consent from the assistant.
Well, that's the bit we have to look at very closely. Grant your first stage, myself I find convincing, that he must have been, at least in one sense, awake, able to get out of the car with assistance, walk, stand while the front door was maybe he leant on the car, but still stand while the front seat was pushed back, and then he would have, I agree with you, to be encouraged to step in and sit down on the back seat. He couldn't easily have been carried or pushed there. But that doesn't require a high level of consciousness or a high level of cooperation. None of us are doctors, but we're all, I think, aware of people who are half awake, maybe having been drunk previously, or simply just having been very heavily asleep, who hardly know what's going on, but will help you enough with some task you have to do to help them in the middle of the night, and then they go straight back to sleep again. Would that be sufficient consciousness to say that they were aware what was happening in the sense that is necessary for our purposes?
If I may, can I answer that in a slightly different way, which is to take issue with one of your Lordship's propositions. It's a bit more complex than that when you go through the various manoeuvres that have to be done, and you think about the time that it would actually take to do it. So simply to say this is something that you could get someone who was in a half-asleep, semi-conscious state to do is not, in my submission, the way in which it should be analysed. That's the first point. The second point...
Sorry, why not?
Because it involves more. What's involved in this? I mean, it's looking at the process, and I appreciate that your Lordship may look at the process and come to a different view to me.
No, but I'm not being picky. I'm just trying to understand what more does it involve? What have I missed?
Oh, you haven't missed any of the actions. I'm just saying that if you look at the actions as a whole, you've got to undo the belt, get out the car, stand outside the car when someone moves the seatbelt, and moves the seat back, assuming they do it. That whole process is not something that one readily associates. You've then got to bend your head to avoid it being bumped on the car, and then you get in. That is not something, whilst it's a relatively simple manoeuvre, it's not just something that requires no awareness at all. No. And the judge reasonably found that it implies a level of awareness of what's being done.
Yeah.
And once you have that level of awareness, it just stands to reason that consent was followed with it. Because if you don't agree to it, you don't do it.
Consent to what?
Getting in the back of the car at this stage. But I do follow up on the basis of the same facts as the judge did, and commend the judge's reasoning to you. If I may come to that in just a moment, I know that I have to grapple with that. The other aspect of this is that you can take advantage of the presumption of capacity. And the thing about that presumption is it's not a creation of the Mental Capacity Act. It reflects existing law, that people are presumed to have capacity unless the contrary is shown. And the judge was entitled to use that as a tool to assist in his decision making. Even if you find that he was not so entitled, then I rely on the analysis that I've just set out for you.
Well, I'm interested in that last point. Is there authority for the fact that there is in any issue where any question where capacity is in issue, there's a presumption of capacity unless disproved? I'm not saying you're wrong. I just don't. I haven't come across it.
What I'm saying about that is that's what the Act says, and it reflects the existing law.
But if it's common law, where would you find it in common law? If I'd been looking at this before 2005, where would I have found it?
You would find this in Masterman Lister, for instance, which was before 2000.
I remember that.
Because the claimants have to prove the lack of capacity.
Yes.
Yeah. And it derives from everything is presumed to be regular unless it's not.
Yes.
As common law. How far that takes you is, of course, a different point.
I accept that. If you're looking for the paragraph in Masterman Lister, it's not in the list of authorities, but it is.
No, don't worry. You want
Paragraph
17.
What's the reference?
I've only got the generic reference. It's 2002 EWCA Civ 1889 at paragraph 17.
2002. Sorry.
EWCA
Yeah.
Civ 1889.
Okay.
Paragraph 17.
717.
Okay.
Just before we allow you to go on to the point you want to make next, I didn't, I'm afraid, in my pre-reading look at the Mental Capacity Act in the Act itself as opposed to in your skeletons. Does it?
Very last reference, H35.
No, I've got it now. Section 1 says the principles apply for the purposes of this Act.
Yes.
And 2 says for the purposes of this Act, the person lacks capacity. I'm not trying to make difficulties, I just want to feel firm ground beneath my feet. The judge did actually do it by reference to the Act, not the common law. Does deciding whether someone has capacity to make a decision which is being relied on as fault under the 1940 Contributory Act 1945, is that one of the purposes of this Act? Where are the purposes of this Act identified? Sorry to be tricky about this. Because we're all very used to it being used in questions like consent to medical treatment or sexual relations in some recent cases. Don't think it's used, perhaps none of you will be able to tell me, if a question arises in a criminal court about consent to sexual relations, that's not covered by the 2005 Act, was it?
No, it's not.
No. So that's just why I'm feeling out actually whether the 2005 Act directly applied at all.
And your lordship may be thinking that this has particular relevance to court of protection questions.
On which we have the world's expert on my right.
I've just asked for the book to be brought to court. Another way.
I mean, speaking for myself, and I think for everyone in the case, we're not sure that the complication of referring to the 2005 Act was really necessary, but it happened, and it was part of the judge's reasoning, so we ought to bottom it out.
Part of the reason why it happened is because of the way the case was put. You've
Yes.
already had a look at
Yes.
particulars of the
Yeah.
claim. But
Capacitors was the word.
yes,
That's not a word in common usage, except outside the court of protection.
And can I ask and invite you to look at the unagreed bundle? I'm not going to take you to all the references because the references are in my skeleton argument. But just to take you to one of them, which is paragraph 29 on page 10. It's not the only one, and the full references are in the skeleton argument.
So this is the claimant's skeleton.
This is the claimant's skeleton.
Yeah.
Where
it's the second and third sentences.
Yeah. And then the reference to spill. So
Hang on one second.
it's paragraph 29.
Yes.
And the other references, so that your lordships are aware, which I'm not going to take you to in oral submissions, are at paragraph 16 of my skeleton at page 50 in the call bundle.
Hang on one second. Para 16, did you say?
Para 16 at page 50. That's of my skeleton, in which I give the other references in the trial skeleton.
Yep, thank you.
Sorry, paragraph.
Paragraph 16 on page 50.
Page 15.
Page 50, I'm sorry.
So you're saying, sorry, you're saying your skeleton for here,
Yes.
paragraph 16, gives the references to your skeleton below.
No, my references for here gives the references to Malone and Friend's skeleton below to the other
Oh, I
points
see.
which he raises capacity.
Thank you.
Just on the 2005 Act, I note if you look at section 2.5 or 2.4, it says in proceedings under this Act or any other enactment, any question whether a person lacks capacity within the meaning of the Act must be decided on balance of probability, which rather suggests the reach is further than just proceedings in the Court of Protection.
My Lord, I'm grateful for that. Yes.
Just so that you don't think there's unanimity on the bench on this point. Yes. It's a question whether a person lacks capacity within the meaning of this Act. It's slightly circular, isn't it? So you may be envisaging this Act or any other Act which refers to the 2005 Act, which obviously the 1945 Act doesn't.
Well, my Lord, it may be, and in the end, we may be arguing about whether it's simply a useful tool,
Yes.
or whether it's compulsory to look at it.
Yes.
The fact remains that this was a road down which the judge was invited very clearly, not just by the pleading, but by
Yeah.
the skeleton.
Whether or not the 2005 Act applied as such, the issue which we're exploring is, in broad terms, an issue about capacity. Because you accept that, taking the extreme case, if it had been possible that he was simply lifted up bodily from one and put into the back seat of the car, that would not be a voluntary act on his part, which could make
Your argument would be different.
you might have an earlier pure Owens and Brimmel argument, but your argument based on
Yes.
this episode
Yes.
wouldn't what? He's got to. The whole point of your submission is he's got to be awake and conscious and know what's going on.
On the awareness findings, the subjective findings, of course he has to be aware.
And that is capacity in another sense. Yeah.
But on the
Well, not another sense, in other words.
there is the objective argument to which I'll come in due course, because it's not necessary, and the judge didn't simply base his judgment on what he found was the subjective position. He also considered what the objective position
But I'm sorry, I've distracted you enough.
No.
I just wanted to see formally how the 2005 Act fitted in.
Yes.
Is this a fair summary of your position? You're not in a position to make a firm submission at the moment as to whether it technically applies. Maybe Section 2.4 gets you home, maybe it doesn't. But as a matter of substance, the questions which the judge asked under that heading would arise anyway.
That is certainly true, and I can't take the point as to whether it technically applies any further. I have.
What was your paragraph in the Masterman case?
Paragraph 17.
Okay. Thank you.
So, one thing I don't believe to be controversial is, as a finding of fact, is that the claimant, Aaron and Dean, had drunk a lot together. And the finding of awareness as to the extent of the drinking, which the learned judge made at paragraph 54 in his judgment at page 90, flows from that. It is an entirely reasonable inference to draw. So, in my
Sorry, which paragraph? Sorry.
paragraph 54.
Thank you.
So, in my submission, by the time we get to the judge's starting point, it is a proper starting point with a relevant background. And what the judge does is he works through, at paragraph 57, in a rigorous manner, the necessary steps to find whether or not there was consent to being moved and whether it can properly be found that there was consent to being driven away. And I invite your lordships to look at the factors which I outlined to you a few moments ago and look at the way the judge looked at this in his judgment and find that they were, as he said, only consistent. I want to explain that because I do appreciate that that has raised the odd eyebrow. It is difficult when a judgment is being picked over minutely, as is entirely proper in a case of this kind, for phrases to be looked at. The first thing I would say about the phrase only consistent is that it has to be looked at in the context of the paragraph in which it was, which is paragraph 58 on page 91. And the second, which is just as important, is to say it is quite possible, and in my submission the natural reading of that, to read that as if this is the only realistic possibility. Of course it may have been the case that something utterly improbable happened, that there was, I don't wish to be flippant, but
A fanciful idea.
a fanciful idea. What the judge was actually saying is the only realistic show in town, when you evaluate all the evidence, is this. And that is the conclusion he came to. And he came to that on a solid basis, analysing both the claimant's subjective frame of mind and then reflecting back at a later point in his judgment, considering the matter objective. And if I can deal...
So just before we leave only consistent, I think I put it to Mr. Ross that actually it would have been enough for your purposes if he had put it somewhat lower. If he had said, I find that this is the most, that in these circumstances it is most probable that, that would have been good enough. That would have been perfectly legitimate. He's put it unnecessarily high.
Yes. The only realistic inference is how I submit it should be read.
Where do we find him considering the possible explanations?
Well, the Lordship makes a good point. You don't see a rehearsal of all possible alternative explanations within the judgment. But how far does one go down that road? What sort of latitude does one allow to a judge giving a judgment, in even a careful judgment of this kind. What I commend to your lordships is the care with which this judgment is crafted and taken. And I invite your lordships to find that the learned judge did reach this conclusion after careful consideration. So he found that there was simple information, it was a simple process. The fact of moving, because it couldn't be done without him, shows he was moving to the back. It's only consistent with awareness and consent, and in that context, it's consistent with consenting to be driven, because why else? He knew whose car it was, he knew who would drive, he knew how much it had to drink. He was therefore aware that he was embarking on an unsafe course of action. Those were the judge's findings. I commend those findings to you on the subjective front. But you also, in my submission, have to step back and say, well, what would the reasonable sober person have known at this particular point? And there you're back to the list that I gave your lordship earlier, to this whole factual situation. 3 o'clock in the morning, party of 3, 2 of them have come back to the car where he still is. They've tried to start it, that whole process of that. They've had a discussion. One of them is left. He has been prevailed upon to move. It is, in my submission, abundantly clear that the reasonable, sober person faced with that scenario would have assessed, yes, the owner of the car is intending to drive it. He's intending to take us home. He's not ringing for a taxi.
Intending to drive it home, you said.
Well, we don't know what happened after that, but the point about it, and this leads to your lordship's intervention about going towards Oxford. The contributory negligence is established once he gets in the car and it drives away. And where they go to is, in our submission, not...
However far he'd have driven before the accident occurred, it was irrelevant.
Your lordship is inviting
Got
me...
to Oxford.
Your lordship is inviting me to move...
Got to Folkestone.
I thought that your lordship might go along this line, and you properly take me down that road. But the point is that there would have to be something else to happen for one to say he's got in the car, there with somebody he knows is unsafe to drive. That is where the negligence is established.
And that's it.
And that's it.
Even if he thought he was going to drive him home,
yes.
the fact that he drove him to Northleach, or not as far as Northleach, towards Northleach, is irrelevant.
Let me put hypotheticals to your lordship, if I may, where I would say the situation would be the same. Supposing the reasonable sober person got into a car with a person he knew was drunk and said, drive me home. And because that person was drunk, they took the wrong turn and headed towards Oxford. And then there was an accident. It would not avail that reasonable sober person to say, well, I'm sorry, we weren't going home at the time I was in the car. He is still just as negligent. If he wasn't wearing a seatbelt, you wouldn't say, well, it's your contributory negligence is nil because you were going towards Oxford, you weren't going home. The contributory negligence is getting in the car, remaining in the car with someone you know or ought to know to be unsafe. It is possible if one goes further and further to come up with something, but this does not arise on the facts of this case. If I can deal with some of the criticisms that are addressed at the judgment in the learned front. skeleton.
So we now move to your head 2.
Not quite, but almost. This is.
All right, okay. What head 2 was criticism of the judge, but it's a different one. Okay, I'm just teasing you. Okay, that's fine.
It's when my learned friend says in relation to paragraph 57.3 that he recognised the absence of evidence of objection. My learned friend, says he drew an inference based on an absence of evidence. I respectfully disagree with that for reasons in my skeleton of paragraph 19. He simply and carefully recognised the absence of evidence, but did not draw an inference from that absence. He inferred the assent, as can be seen from paragraph 57.4, from the fact of a change of position by an individual of the claimant's height and weight. If you had evidence of opposition, that might cause the inference not to be drawn, and that's why the judge included it. I think, my lord, I should simply have said yes to your first proposition, because I'm about to go on to number 2, criticism
I would never have known.
Approach
Okay.
to the evidence.
Thank you.
And the first set of criticisms involve inferences in general. And it's relevant in my submission that the approach at trial, in the trial skeleton argument on behalf of the appellant, was not that the judge was prevented from drawing inferences. Rather, he invited different ones. And it's important to consider, even if only briefly, the inferences invited by the appellant, as they provide practical context for the criticism of the judgment itself. And I'm only, if I may, again, this is our skeleton, paragraph 55 at page 63, but I'm not going to go through all the observations set out there. I'm only, in fact, going to ask you to look at one part of the trial skeleton in the supplementary bundle. That's page 9, paragraph 22.2. Page 9, paragraph 22.2, the supplemental. It's talking about the seatbelt in this particular context. And it says, at the bottom of that, this allegation is similarly persisted in, notwithstanding the fact that the claimant lacked capacity at the time the defendant's car was driven off, whilst he was still unconscious and unable to take any measures for himself. And it may be obvious, and your lordships are entitled to give this point what weight you feel it deserves. But what the appellant is now criticising the judge for doing, and saying that he entered into the realm of conjecture, speculation and guesswork, is making the very kind of finding that was urged on the judge by the claimant in his skeleton argument. And the court is entitled to consider how the appellant's two positions, the appellant here and the appellant below, can coexist.
Bit of a debating point, perhaps. We've just got to decide whether these were or not legitimate inferences that he did draw.
Well, staying with that subject, if one looks at the guidance on how to approach decisions of the court below, we start our submissions to your lordships by referring you to, and this is paragraph 63 of the skeleton at page, so paragraph 58 of the skeleton at page 63, to the Staplin case, the case about the art agent.
About what?
It was a case about an art agent who was alleged to have wrongfully obtained commission for selling.
This is Lord Justice Lewis.
It's Lord Justice Lewison's observations.
He's we usually get Phage, the case of Phage.
Yes, I'm puzzled by that. I was
the
the same thing. Perhaps Lord Justice Lewison recycled himself.
It's a rehearsal, to use his word.
Well, that was the eye-catching part of the text. And I do hope that was Lord Justice Lewison's own work. And I haven't,
He said that before in the Phage case.
Island hopping. Yes, it's full of quotes.
I do
You've cut and pasted it into our judgment many times.
I haven't robbed another judge of credit for
It's the same judge,
different
different judge.
phrase. But it is this business about the trial being where all these things are decided. Yes, it is.
In fact, yes, I'm afraid the passage you start says, if I may repeat something I've said before, and refers to Phage. That's what confused all three of us, I suspect, have been referred to Phage, if that's how you pronounce it, dozens of times, but never to Stacklin. But the answer is he was quoting himself. You got to the bottom. It's a very well-known passage, yes.
Well, if it's a very well-known passage, I will not expand on it. But what I say you can draw from that, and the caution expressed in it, is that the judge in this case did three things. He found facts. He had to find them. He drew inferences from the facts. And then he evaluated the evidence as a whole in order to come to his conclusions. And it is difficult in our submission at appellate level to separate those matters out. And that is a task that should be approached cautiously.
I think the dicta in Phage or dicta perhaps, are most appropriate to a case where there is live expert witness, evidence, and also to cases where there are lots of issues and interlocking of issues. But this is a very narrow intellectual exercise based on some very specific facts, limited facts. Not quite so opposite, is it? We still have decided the judge was wrong, of course, not just that we would have reached a different conclusion.
I accept that live evidence puts a case into a different category. But that doesn't mean that you should not reflect the role of the trial judge as compared to the role of the appellate judge.
The advantage which the trial judge has over us is that he or she hears the competing evidence, and and I think if we go to the Phage approach, you'll see a reference to the courtroom. I seem to remember appearing somewhere in what Lewison said. So this is a different technique because nobody here gave us sadly available to give evidence
on this particular issue. No, but that's still the trial process is there to get at the facts. The appeal process is to scrutinise the trial.
Isn't your better? I mean, aren't you risking putting your case unnecessarily high? In a case where secondary facts are being inferred from primary facts, you're still entitled to say more different judges can reach different inferences from the same facts. And the mere fact that we might think that this was rather an inference that went rather further than we would do on the same facts isn't enough for the appellant's point of view. We have got to say he was wrong to draw that inference. If that's your submission, it's very soundly based.
I'm not moving beyond that in what I say. I do. What I will.
When I say it's soundly based, I'm sorry, I don't mean it's right. I mean it doesn't go beyond the authorities.
What I wanted to communicate to your lordships and why you see references to Biogen in the skeleton argument. It's a well-known passage. It's rehearsed in the skeleton argument, paragraph 59.
Yes, well, I'm sorry, I hadn't seen you put in Biogen. Well, that really.
primary evidence. This was primary evidence, even if it wasn't oral evidence. What's your point? Well, that does, to my mind, drive us back to the only consistent
point. Because we've got to be satisfied, haven't we, that he addressed all the issues. And you've already conceded that he didn't expressly.
Well, you wouldn't expect him expressly to address every conceivable issue because the judgment would go on forever. And what I am urging upon your lordship is that you're reading too much into that phrase. Only consistent can be equivalent in meaning to only reasonable inference, or the reasonable inference in this case. And it is not a requirement of a judgment to go down every alleyway once you have properly formulated conclusions and evaluation.
What do you say to the point that he has to consider not only the facts but also the absence of facts, the holes in the case that we've identified earlier? Why did he leave Aaron behind? How did he stop the car? Why was he in Northleach?
I don't think it is. In our submission, it is not necessary to consider some of these things because they're not central. They're not. You do leave strands untied. What you can see within the judgment is an awareness of the boundaries, not just in the explicit way in which he set himself and the reference to it, but also in the actual fact that he refused to make findings on certain issues. He evaluated the evidence and made the findings he felt he was able to do.
It would have been very odd to speculate on there could have been third parties when there was no evidence of that, and you were talking about a side street in the middle of the night. Of course, some judges might, but judgments would be very long if everyone put in those. And when we direct juries in criminal trials, we tell them explicitly not to decide every point which arises, but only such as are necessary to decide whether the defendant's guilty or not.
So, in those circumstances, unless I'm specifically invited to do so, I won't take your lordships to the passages in Whitehouse and Jordan in the judgment of Lord Wilberforce, which aren't in the skeleton argument, but are also relevant on the task of the appellate court and finding the judge was probably wrong.
Well, unless they say something that's a lot different from what we all understand, I don't think you need. They're in the bundle, are they, if we need them?
They are, and the reference that I have is tab 2, A20252G, and in Manning, the observations of Lord Justice Morris Kay at page 110, that's in tab A5, page 110.
What's the reference in Whitehouse and Jordan?
Sorry, it is page 20, A20252G.
Well, speaking for myself, I don't want to be taken to them, but
And then Lord Justice Morris Kay, page 110, paragraph 14 in Manning, which was the photographs of the Tribune case.
Whitehouse and Jordan was a medical negligence.
It was a medical negligence case, yes. So, in conclusion on this part, we do stand with the judge and repeat it was a careful judgment in which the judge came to conclusions to which he was entitled. Can I then turn, unless I can assist your lordships further, to the proposition that the test is objective?
Yes.
There are three propositions behind this. Broadly, again, I commend to your lordships the approach of the judge. But the three propositions I make is that the test for contributory negligence is objective. Owens and Brimmel did not introduce a special test for cases where the contributory...
This is your second proposition?
Yes.
Yeah.
Where the contributory negligence was consent to be driven by an unfit driver. And thirdly, you can see the approach worked through in the earlier decision of this court, and the decision of Lord Justice Brooke in Booth and White. And here I'm following quite closely the respondent's skeleton argument, starting at page 55, paragraph 31.
Yes.
Paragraph 31 quotes the Act, and I don't need to expand on that. And then paragraph 32 contains the well-known quotation with regard to contributory negligence from Campbell Butcher. The important gloss on this is that this was the passage to which Mr. Justice Watkins directed himself in Owens and Brimmel. And it is a passage that makes it clear that what we're looking at is an objective standard. Bottom line, if he did not act as a reasonable, prudent man, he might be hurt himself.
I mean, that's got to be glossed a bit. Certainly by reference to children.
Yes.
And my Lord put to you, and I think I associate myself with this, cases of people whose ability to act as a, quotes, a reasonable, prudent man is impaired by illness or some sort of, I forget what phrase he used.
Extraneous characteristic.
Extraneous characteristic. Well, that's illness, isn't it? Extraneous characteristic, but in any event, yes. You're happy with that. You just say drunkenness is not, self-induced drunkenness is not such a case.
I mean, a person with Parkinson who falls off the edge of a pavement is never going to be treated, or should never be treated by the law in the same way as you or me.
Absolutely. And that is why we rely on the only academic commentary which refers to this particular issue, which was the Charlesworth and Percy commentary. The commentary within the appeal skeleton document came from the edition before this case, so one doesn't get too circular about it.
And that's some, yes, I see. Did we find that actually in the edition, in the one we were given, did we find that self-same passage?
I think we still do. Would your Lordship give me a moment to have a look? I think it is still in there, but it relies on this case for its
I was looking this morning.
What divider is this?
This is
It's
G27, page 486. Yes, it's still 453. Excuse me, this must be disregarded.
Yeah. I'm sure it is. Just show me the passage.
If you look at page 486,
yes,
in the box, it's the top part of the passage. The little U for update has, I expect, taken into account this case as well.
So I'm still, am I being stupid? I'm still looking for a phrase, negligence depends on a breach of duty, whereas contributory.
Oh, no, I'm sorry, that's from Prima Butcher. It's paragraph 33.
Oh, I'm so sorry. You're right. Dear, oh dear.
But you're referring to in top
Yes.
the first two lines on
Yes.
453, which if you look at note
Yes.
157 does refer to this case at first instance.
Yes. But you're saying that was there even before that?
It was, yes.
Without any authority,
Without any authority.
just as a statement of what
It
they
was-
consider to be the right principle.
My recollection, I can't swear to it, my recollection is it
And
just
Mr.
went
Ross
on.
is nodding as well.
All I would add is they were the only ones who went that far.
And I don't know how much to trouble your lordships with the Australian authorities, but the reasoning in Morton and in Jocelyn is, in my submission, powerful as to why this should be so. And here I'm looking at page 56 and paragraph 34 of the respondent's skeleton argument, where I quote a passage from Morton, and it's really the bit that starts about 6 lines down, talking about to hold otherwise is to render an injustice to persons who remain sober, and then going to the end of that passage.
Yes, and this Justice Cooper does in fact refer to quite a lot of academic authority. I think there's something here from the Modern Law Review. I think there's another article in the LQR, which we haven't got, but it doesn't matter.
My learned junior was very active over lunch and has got the Modern Law Review, so he can forward it to your Lordship's legal assistance if it would help.
Well, let's have it for completeness. But I think for the moment we'll take your submission as being based simply on what...
On that extract.
And what do you say the answer is to what the Chief Justice said in the Macpherson case, which is, well, it's all very well to be austere, but what about a bit of humanity in some of these decisions?
I say that, well, first of all, I say that the Chief Justice was, in fact, that decision has been criticised by the High Court of Australia by Mr. Justice McHugh. And I say it isn't about humanity. If you're looking at wider social goals, the goal of discouraging people from becoming so drunk that they lose their capacity to assess whether it's safe to enter a car with someone is a valid social goal. And I would also say that there are implications for the integrity of the system and for fairness more generally, which were referred to by Mr. Justice Cooper when he talked about the 2 people in the hotel room. And why is it fair for the more sober one to be afflicted with contributory negligence when the less sober one isn't? As I put it to the judge at trial, it would be, in my submission, a bad state of affairs if someone could say, well, I would have been contributory negligent if I'd only drunk 4 pints, but because I drank 12, I'm not.
Perhaps these points should be reflected in quantum in assessing the level of the deduction rather than the principle.
I would submit to you, my lord, that that's not the right place for them, because you have 2 people standing side by side, the 2 people in Mr. Justice Cooper's hotel room. Hotel, I think, in this context is Australian for bar.
I think the Lord agrees with you.
There has to be a parity of justice between those 2 people, and that is achieved by objectivity. And that is why that is something that impressed itself on the learned judge, and you can see that in the judgment at paragraph 74, which is at page, I think it's at page, sorry.
Yeah.
Yes, page 94. He said, and I would submit correctly, it seems to me to be thoroughly unattractive that a mildly drunk person might be guilty of contributory fault for making an unwise decision, whereas a person who deliberately consumes so much alcohol they're unable to appreciate the foolishness of their decision is in a better position in law.
Just in case we get tempted into going to the Australian authorities, Mr. Justice McHugh does, broadly speaking, support the position you're taking. Arguably, he goes a little too far because I think he disapproves an English decision. Mr. Justice Stable saying, well, if we take into account the age of a child in contributory negligence, so we should also take into account the age of an old person who made judgment may be impaired by age. McHugh says no. And if you look at paragraph 39, Mr. Justice McHugh says, nor did it make any difference that the pedestrian or driver, and I think that means, just because of the example he's given, that means that effectively the passenger, the claimant, had defective hearing or sight. You might have an argument, if your hearing is so bad, you must look, or something like that. But you've got to take it into account, haven't you?
Well, I've already agreed.
I thought so, but I just wanted to spell out that it's just, these things are not straightforward. Even though he's on your side, he goes a little bit too far one way.
No, and I would perhaps, whilst looking for Australian judges on my side in the High Court, draw to your Lordship's attention paragraph 76 in the judgment at page 445.
But there was criticism, I think there was academic criticism of Mr. Justice McHugh about being too austere, which is why I put it to you, that it was a bit austere. 76.
Paragraph 76, which is part of the Gunmo and Callanan judgment.
Yeah.
Now, I appreciate it's discussing, as far as one can tell, the Motor Accidents Act. But the bottom person in the position of Mr. Berryman ought to have known, and in fact would have known if he'd not precluded himself from knowing by his own conduct, that Ms. Jocelyn's capacity must have been impaired, and probably grossly so. So it is support for the objective standard. And unless I can assist your Lordships further, I do refer to paragraph 39 in my skeleton argument, and that has some observations of interest, but I can see that your Lordships have read this judgment thoroughly. Can I move on to my second proposition, which is that Owens and Brimble doesn't provide a special test? You can see that, and here I'm at paragraph 39 of my skeleton argument on page 58. You can see that from the fact that Mr. Justice Watkins directs himself in Owens and Brimble to what was said in Froome and Butcher and describes his process as based on the same fundamental principle as in that.
Well, he didn't have any choice. He was suing the first instance anyway.
Yes. And inevitably, the judgment of Mr. Justice Watkins was focused on the facts in front of him. I could not find any reference to prior agreements, although it is implied in the head note. But it's a judgment on its facts, on an issue of contributory negligence. It doesn't provide a template or a grid for these sorts of cases. And if anything, if you are sifting through that judgment, and it's at E17 in the authorities, if you're sifting through it, what you find is references, one of which was discussed before lunch, to the fact that being befuddled by drink is not an exculpatory state to be in. The bit that was not discussed in terms before lunch was the bit on page 337 behind E17 at G, where he said...
So sorry, which page in the bundle?
337, it's behind tab E17.
Oh, sorry.
867G.
Just give me 1 second, I've been slow. Yep, I have it now.
There he said, I think this is a clear case on the facts of contributory negligence, either on the basis that the minds of the plaintiff and the defendant behaving recklessly were equally befuddled by drink so as to rid them of clear thought and perception, or, as seems less likely, he then goes into actual knowledge. But it's clear from his way of thinking in that case that he did not regard being befuddled by drink as any kind of exculpatory state to be in.
So that note in Charlesworth should have referred to this.
Perhaps it should.
Well, I think it, yeah, funny enough, I'm not sure. Another bit of it in Charlesworth does refer.
It does a bit lower down, yes.
Yes.
And that is why we submit that this is an objective test, and we submit that it would be bordering on absurd if the test were different in one situation to the test in other situations, which is what ultimately my learned friend is inviting you to find.
How helpful is it to look at other circumstances in which court disregards the fact that you may make an unwise or reckless decision as a result of drink?
I'm not quite sure what your lordship has in mind.
Well, in the context of sexual consent, I think, well, since I've sat on a jury, the jurors are still told that consent, I think, needs a bit of spelling out, but the shorthand is drunken consent is still consent. But that only goes so far. If you're completely incapacitated, then it isn't. Are we in the same sort of territory? Was that an unhelpful analogy?
When preparing for this case, I looked to see if there was anything helpful I could get from the criminal jurisdiction. I didn't, but I made simply.
No, well, it may not be a good idea, but I thought since we're looking at the law generally, I ought to just raise that with you. You're not seeking to support your submissions by reference to other areas of the law.
No, but I am seeking to support my submissions by reference to other areas of contributory negligence involving alcohol. If I could ask your lordships to look at D16, page 324 of the bundle, that's the drunken pedestrian in London.
Just before we leave the criminal law, I mean, there is also a principle of criminal law that it's no defence to say that you wouldn't have done it if you were sober.
Yes.
And that is clear. And if you then form a specific intent, even a drunken specific intent, that's enough, for example, for murder, even if I wouldn't have murdered you if I was sober.
Well, your lordship is ahead of me, and those broad principles may assist, but I don't put any criminal authorities before.
Thank you.
I ask your lordships briefly to look at London Khalifa, because there's, in my submission, a good analysis of how one should look at alcohol in the context of contributory negligence, paragraphs 17 and 18 of that.
Where do we find Lund?
It's page 327, D16. It's the part that's boxed.
Slightly different point, isn't it?
Well, it highlights the importance of what you do, not why you did it. But you can't say, I did it because I was drunk. So that's all I have to say on the second proposition. The third proposition concerns
Sorry to interrupt. Just before you leave that, are you going to deal with Booth and White or not?
Yes.
I'm just about
That's
to
your
move
next
to
point.
Right. Okay.
The third proposition is the approach in Booth and White. And I would endorse and adopt as my submissions what the judge said in his judgment at paragraph 64 to 67 about that case, which is in the core bundle at pages 92 to 93.
No doubt, because it reflects submissions made by you to him first time round.
There are the central point about Booth and White is
Which paragraph of the judgment again, sorry?
paragraphs 94 to
Thank you.
excuse me, paragraph 64 to 67 at pages 92 to 93. Before reading those paragraphs, can I say a couple of things about the facts? Malone Friend described it as a pub crawl case. It wasn't a pub crawl case. It was an assessment case.
What case, sorry?
It wasn't a pub crawl case. It was an assessment of the driver case, in that Booth had stayed at the same pub, the White Star or the White Hart or whatever it was. White had gone off to play football and then come back and then offered Booth a lift home. And Booth accepted that he'd stayed at the pub drinking, but not in the company of White. And various questions, it's most often relied on because counsel for the defendant urged upon the court the proposition that there was a duty to ask White how much he'd had to drink. And it was accepted that if he'd asked White, White would have told him he'd have had the necessary knowledge. And the Court of Appeal found that it didn't go that far. You had to make an assessment, but that did not necessarily involve asking questions. Booth won, although he had drunk 15 pints and was, on his own admission, in no position to make an assessment of the fitness of White. As is clear from paragraph 20, Booth won because his wife turned up, and his wife was sober. And his wife said White didn't look drunk, and she wasn't cross-examined about that. And so any negligence on the part of Booth in failing to make an assessment didn't have any causative potency. And that is the explanation for the bottom of paragraph 20
In the judgment.
in the judgment, page 379. No, the judgment is the Court of Appeal. Paragraph 20. Bottom part, which the judge quoted in his judgment. The law requires the passenger to make an assessment of the driver when in deciding whether in the interests of his own safety he should have a lift. The judge relied on Mrs. Booth's evidence and the assessment that her husband would have made if he had been fit to make it. So he won in that case because there was evidence that had he made an assessment, he would not have been able to tell that Mr. White was unfit to drive. But on his own admission, he wasn't capable of making that assessment.
That all turns on its facts then.
It turns on its facts, but it shows that it's objective. It shows that the requirement to make an assessment is to make the assessment that a reasonable sober person, in this case Mrs. Booth, would have made. So that is a working through of the same issues in this case, in that case. You must judge, in my submission, you must judge the actions and omissions of the claimant by the standard of the reasonable sober person, the Mrs. Booth.
I note the judge referred to paragraph 10, but that's one bit that isn't in the red boxes.
Yes.
Because this is where the Court of Appeal set out without criticism the judge's analysis that Mr. Booth couldn't rely on his own drunkenness.
Yes. Thank you.
But it was an extemporary judgment, it seems, wasn't it?
Yes. It was on the Judge Curl. So,
No, in the Court of Appeal.
in the Court of Appeal, oh,
Looks like it, doesn't it?
Short.
unless your lordships wish me to, I don't have anything beyond what's in my skirting argument in relation to Brignall and Kelly and why that case should be distinguished. I would, if I may, draw your attention to a case that's relied on by my learned friend, which is the case of Griffiths, which you'll find behind tab C11. This was another High Court decision by Section 9 Judge, I don't know if it was Section 9, is Honour Judge Graham Jones. The facts of this case is it's an accident in 1992 on Kilburn High Road. At about 11 o'clock in the evening, the claimant, Griffiths, and another were passengers in a taxi driven by Lindsay, and they were drunk. And Lindsay took them, they wanted to go to a cash point. He took them and dropped them on the other side of the road from the cash point. Griffiths crossed the road and was hit by the driver, Brown. And that part of the case is in my submission of no assistance here. But Lindsay was brought in, the taxi driver, on the basis that he'd dropped a drunk individual on the wrong side of the road, meaning that he had to undertake a dangerous manoeuvre, namely cross the road. And it's that part that I would ask your lordships to have a look at, and in particular, the part at 242, where, starting just with a couple of words on 241, the learned judge referred to the duty of a taxi driver to take reasonable care to carry his passenger safely during the journey to the stated destination, to stop at the conclusion of the journey or part of it in a place where the passenger can safely alight.
Where are you reading from, sorry?
I'm sorry, that's the bottom of page 241 and the very top of page 242. And then if you ignore the next paragraph, it starts the second full paragraph on that page, page 242. Why should the position be any different? Because Mr. Griffiths was inebriated. Why should there in effect be some special duty to him, simply because he was not sober? Why should the scope of the duty be different in respect of an intoxicated passenger compared with a sober one? And he answers his own question, omitting a paragraph. At the top of the paragraph following, in my judgment, the duty is the same whether a passenger is inebriated or sober. Talking about the potential for harm, in the penultimate paragraph, last sentence, the potential harm, if such there was, arose only by reason of his own actions in consuming alcoholic drink. And he then draws a distinction between the position of Mr. Griffiths and people with other characteristics, such as children. And he's fortified by that over the page, on page 243, by a passage from the judgment of Lord Justice Belden in the case of Barrett and the Ministry of Defence, which is a case of a Royal Navy, a member of the Royal Navy, unfortunately, choking. And what Lord Justice Belden said in that is, I can see, this is 3 lines down in the quote, I can see no reason why it should not be fair, just and reasonable for for the law to leave a responsible adult to assume responsibility for his own actions in consuming alcoholic drink. No one is better placed to judge the amount that he can safely consume or to exercise control in his own interests as well as in the interests of others. To dilute self-responsibility and to blame one adult for another's lack of self-control is neither just nor reasonable. And then the development of the law of negligence, an increment too far. And we submit that those observations have some relevance to this case, because that is in effect what the submissions of my learned friend are trying to persuade you to do. My lord, unless I can assist you further on that, to turn to contributory negligence.
Yes, you mean apportionment. But can I just work out how this applies to what, on your case, the claimant should be taken to have? No. If you look at para 60
Para 60
of the judge's judgment,
excuse me, my lord.
there may be another panel. I'm sure this is quite the passage I had in mind, but this will do. The judge appears to have regarded it as necessary that he should find that the claimant was aware of how much Dean had been drinking while he was in the club.
Certainly that he consumed so much that his ability to drive safely was impaired.
But was it necessary that he should have been aware of that fact? He's got to have been, put it crudely, conscious or capacitous.
Yes.
That's what we've been looking at earlier. But once that level is reached, isn't the question whether a conscious and capacitous man at that point should have been aware of the risks and of the facts that went into the risks? He should have called to mind, hang on, we've all been drinking for 3 hours and drinking a lot, and that doesn't, it's not strict. I may be an angel jumping on the point of a pin. No, sorry, that's mixing my metaphors. I may be being over-refined here, but it's not so much actually what went through the claimant's mind if he was conscious. It's what should have gone through his mind.
Yes, you could. The judge was looking at it in the first sense and only referred to the second sense later, but I agree.
Yes. And the two very easily meld into one another. But it's do you accept what I put to Mr. Ross, that we've really got a two-stage question here? You first got to decide whether he was, use the ugly phrase, capacitous, which is roughly, could be translated as knew what was going on, was conscious and so forth. There may be subtle, maybe a different line to draw exactly, but conceptually that's one line. Once you decide he is capacitous, it doesn't matter what he was thinking. It's an objective test.
Yes, but that I agree with that. But you could have a position where someone, because of their drink, rendered themselves incapacitous, and that would not assist them.
Oh, you've got to be careful with that argument. Supposing by his, or at any rate it's a different argument, suppose it's a more extreme argument. Suppose by his drinking he had rendered himself incapacitous, and the facts were that he was in a drunken sleep all the time, even when he moved seats, contrary to the probabilities, he was simply lifted from one seat to another and they drove him off. That would be
Can I take your
a
lordship?
more difficult case for you.
One then goes to the objective standard. And can I take your lordship one stage further back? to answer your lordship's question, if I may, because I think it gets difficult if you get serious. If the claimant had fallen asleep in the club and remained asleep with no concept of what was happening, perhaps because he was so much further ahead of his companions that they were not at a state when he would even have assessed them as drunk, and he was then carried to the car and driven, the reasonable, objective person would say, well, he's not to blame. He's not to blame in those circumstances. But that's an extreme example, and your lordship does not need to look at those kind of extreme examples when considering the facts of this case.
Okay.
Unless I can assist your lordships further on these points, I propose to turn finally to the issue of contributory negligence.
Apportionment.
I apologise to your lordships. My capacity for learning is obviously limited to the question of apportionment. And I start with the propositions at paragraph 53 of my skeleton, which your lordships will find at paragraph 27 of my skeleton, which your lordships will find at page 53. In our submission, this is a simple point. We argued for more, we got less. There is a band in which a judge can make an award, 20% falls within that band. And I paraphrased the well-known observations in Jackson and Murray in saying, as I do at the end of that paragraph, in the absence of an error of law or fact, only a difference of view on apportionment which exceeds the ambit of reasonable disagreement warrants interference. So I don't ask you to put it up. But if your lordships need persuading that 20% was, in our submission, if anything, generous to the claimant, then in our submission, reading of some parts of the two cases in which more was awarded does assist. So at EAT, you have the case of Mere. And I'm looking at page 371. In that case. Where Mr. Justice Wolfe said this: I have no doubt at all on that evidence.
So, sorry, which paragraph or which page?
This is the box paragraph on page 343.
Yes, thank you.
I have no doubt at all on that evidence that if the plaintiff had not himself been affected by drink, it would have been quite obvious to him the defendant was not in a fit state to drive. There was an obvious risk in accompanying the defendant in that motor car, and that this is an appropriate case, therefore, in which there should be a finding of contributory negligence against the plaintiff on the basis of the approach indicated by Mr. Justice Watkins. Although urged by the defendant to take the view that this was a case which was considerably worse than that described by Mr. Justice Watkins, and treated on the same basis as Watkins by counsel for the claimant, I have come to the conclusion that the plaintiff is entitled to succeed in this case because there was clear negligence on the part of the defendant, but that he was also negligent, and that the appropriate proportion of blame that he should bear is 25%. And as I have reproduced for your lordships in the respondent's skeleton argument, what was submitted to the judge at trial, that is at page...
This also goes to the issue of objectivity, doesn't it?
It does, yes.
Yeah.
page 68, paragraph 71, we submitted that this was a serious case where Dean and the claimant spent the evening together getting progressively more drunk. It was a second journey which the claimant allowed himself to be driven by Dean because he'd been driven to the club as well after Dean had consumed alcohol, because there's a finding that alcohol was consumed at Aaron's house before they went to the club, tequila, and that's in the judgment. The words of Mr. Justice Wolf apply to this case. It should have been quite obvious to the claimant that Dean was not fit to drive and that he was taking an obvious risk in being his passenger. We submitted the minimum standalone deduction in this case should be 25%, and the court may feel that the risks taken by those who allow themselves to be passengers of intoxicated drivers are better understood and less tolerated than they were in 1977, when Mr. Justice Watkins gave his judgment, or even in 1985 when Mr. Justice Wolf decided near that 30% would be reasonable. That was our submission, which placed it below the Stinson case, which we accepted was a more serious case where a deduction of 33% was made. And we accepted as a principle that as the driver, Dean must always take the lion's share of the blame. So, unless I can assist your lordships further on the issue of contributory negligence or on any other issue, those are our submissions.
You mean apportionment?
Oh no.
You meant apportionment. Not as far as either of my lords are concerned or myself. Thank you very much. Yes, Mr. Ross.
Lord, can I deal with apportionment first, because that's fresh in our minds.
Yes.
Important issue in our case, in our respectful submission. And if I could take you back to my speaking note, briefly, in this regard. It's at page 16, I think, of yours in the box.
You distinguished Mayor.
I've distinguished Mayor. Can we go therefore to Mayor? It's 339, my lord, in the bundle. Your lordship can see that this is a deliberate drinking expedition where D was always going to be designated as the driver to drive home. That's a distinguishing feature.
So where you say we will see this, where will we see it?
We will see it if you go all the way through 342, my lord, and the top of 343. We just invite your lordships to read that.
Well, the first paragraph on
342 at F, my lord. PC, former PC firm. Same blood alcohol level as here.
So I'm getting a bit lost. I appreciate this as a reply. What's the particular point of Mr. Kennedy's that you're meeting?
The distinguishing feature in this case, which is why the level was selected of 25%, was that the court could see that it was a deliberate, pre-arranged pub crawl at which the defendant was going to be the designated driver.
Yes, well, surely all we need is the passage which says that. Then.
Yes, well, I think it's
Bottom of
342,
top of 3-4.
and the top of 343.
Okay, thank you.
What's more, it was elicited from cross-examination. He'd left his car behind and travelled in the defendant's car because they knew they were going drinking.
Okay, thank you.
Similarly, the other case relied upon is Stinton.
Well, I don't think he did rely on Stinton, did he?
Right.
We weren't taking Stinton.
It said that Stinton was a more serious case.
Good.
We accepted it.
Sorry. Well, if you want to take us to...
No.
I'm only anxious to keep a reply as a reply, rather.
Yes, indeed. So you've got the passage there in my speaking note that the finding of the trial judge in Stinton was blameworthiness to the greatest extent possible short of direct participation in the driving. Now, in this case, my learned friend has indicated that the judge found that they had drunk alcohol at Aaron's,
Stinton
house.
was 35%.
Yes, it was.
So how is it relevant in deciding whether 20% was right in this case?
No, I'm distinguishing it.
Yes, but he isn't relying on it, so... Is he? I mean, I don't want to be unfair to you, but I didn't...
It's because he mentioned it in his skeleton argument. That's why I've addressed it, that's all.
Yeah, well, all I understood him to be saying in his submissions just now was that Stinton was very different.
And you've covered Stinton yourself
And I have covered it.
Yes, fine.
in your speaking note.
Anyway, I'm making a note of
Yeah.
what about Stinton. Yeah, thank you.
And similarly, in the case of Owens and Brummel itself, and His Lordship, Lord Justice Dingemans asked me to indicate where there had been a pre-planning. Now, if you be kind enough to look at the head note, it's clear from that this was a case where there had been a decision to go out driving.
Yes,
and
well,
drinking.
I think when we were looking at it before, we all noticed it was in the head note. We were saying, where's that reflected in the judgment?
Well,
That was the point.
I hope this assists.
Yes.
331.
Give me one moment. Head note writers don't always get it right, but sometimes they do. So you'll notice how they do here. Yeah, we've got 331. G.
Upon some of those occasions, they travelled in the defendant's car. The plaintiff, who does not drive, although he's been taught to do so, knew that what seatbelts were for, etc., etc. It maintains, so there's a seatbelt issue in relation to that. If you go to B over the page, defendant's version of the events is that he picked up the plaintiff in his car. They went to one or two public houses and eventually to a club, which they left shortly before 2 a.m. the following morning. The amount they had to drink, the last 3 pints were consumed at a different establishment, a club, and from the club they went to a nearby car park, got into the front passenger seat. And so it's from that His Lordship goes on to say, as he does at the bottom of 336, and over the page at 337, he cites the example, so also may a passenger be guilty of contributory negligence if he, knowing that he is going to be driven in a car by his companion later, accompanies him on the bout of drinking. Those were the facts of this case, and that's why the learned judge found them to be guilty in this case of contributory negligence. In the instant cases, that the plaintiff and defendant drank fairly considerable amounts of beer relatively short before beginning the fateful journey, both reasonably intelligent, blah, blah, blah. They continued the bout of drinking, exposed themselves, I think, more likely, however, that the two of them were bent on a kind of what is known as a pub crawl, and gave little, if any, thought to the possible consequences, were reckless as to it. So the whole context of this is a pre-planned arrangement whereby they go to pub crawl, but it was going to be, from start to finish, the defendant who was going to drive. That's not this case, as the learned judge found. There was no pre-plan for him to be driven home. So the whole of what came to pass at the end of the day, when he was clearly very much worse for drink and had been taken to the car. But for that intervention, this exposure to risk would not have taken place at all. That is why, in our respectful submission, this case is very different from Ernst and Bribble, and why it warrants a contributory negligence finding at a much lower scale than that. Because Ernst and Bribble is a much more serious case in terms of pre-planning for the evening's events. And if the court is then minded to take into account just what a shocking state the claimant was in, forget capacitousness for the moment, in a shocking state, without a doubt. They said how bad he was. When he was placed by them in the car, he was later placed by them in the rear seat.
So are you saying that this is relevant to the amount of apportionment?
Yes, my lord. Because
Is this a
it goes to blameworthiness.
Is this a submission you made first time round, Mr.
Because it
Ross?
goes to blameworthiness.
So if you, in a case where there is contributory negligence, you lost on all the other points,
Yes, my lord.
you say a person who is still by definition knows what's going on, otherwise you wouldn't have contributory negligence,
Yes.
is entitled to have less taken off if he's very drunk than if he's only slightly drunk.
No, I can't,
Am
not generally, my lord, no, but you have to have regard to the particular facts of the case, because you have to have regard to when the blameworthiness commenced. The blameworthiness in this case commenced not because he went out drinking to celebrate his birthday or to celebrate the prospect that he got a job, but because the blameworthiness...
When he got into the back seat. When he got into the back seat, is that what you say?
Well, at worst, when he got into the back seat, yes.
Well, it depends on what basis you haven't succeeded on. You might be when you got to the front seat, but it doesn't matter for the point of view, the point you're making.
He's in a shocking state when these decisions are made, and they would not have come about but for the intervention of the defendant and his brother, because the judge finds, doesn't he, that he thinks that if they had not intervened, he would have gone home by taxi. That's in the judge's judgment. So it's the intervention of the third parties that has brought about the predicament and the risk that he faces. That's why we venture to suggest from start to finish in this case, it is unique, factually.
Anything further on apportionment?
No, my lord, I think that encapsulates it. Lord, I'm conscious of the time.
Well, don't worry about the time. It's a very important case and important for your client. But on the other hand, of course, it is only a reply. So, but don't feel we're going to make you get up before you've said what you need to say.
Thank you, my lord. Now, my learned friend, on the question of whether this man was alive to the prospect that he was going to be driven away, in other words, actual knowledge, said, amongst other things, that the trial judge was driven to find that, that the move of the claimant into the back seat could not have been carried out without his cooperation. And my respectful submission, that doesn't follow from the evidence that we've got before us. It's a lacuna in the evidence. We can postulate all sorts of possibilities, but this is but one of many possibilities that could have taken place. Were there third parties involved? We don't know. If there were third parties involved, they could have dumped him in the back without his cooperation at all. They could have hauled him out and they could have pushed him in the back of the seat. We don't know.
If the judge had said most likely instead of only consistent.
Well, even that doesn't assist with respect on the facts of this case, because there is simply no evidence in that regard. And
we might say there's absolutely no evidence that bystanders helped a wholly unconscious man out and put him into the back of the car. I mean, if one's looking at probabilities, although the judge doesn't address it, it's not the most likely probability that at 3 o'clock in the morning, in a side street in Cheltenham, there would be people who'd be willing to help Dean take the claimant out of the front seat and put him in the back seat. It doesn't sound very likely, does it?
Well, we don't know about the car. You know, was there something being done with the car? Were they asking for help from third parties to help get the car started? All these are unknowns. That's as far as I go. They're known unknowns.
Yep.
And the trial judge has, with respect, sought to fit his findings into a scenario in relation to which there's no evidence whatever.
Well, he hasn't fitted them into the knowns. He hasn't adjusted the knowns. He's stuck to the knowns. But is your point he can't draw the inferences from the knowns because of the extent of the unknowns?
Precisely.
You're not inviting him to speculate, or us to speculate about the unknowns. You're saying the extent of the unknowns was such that he couldn't draw the inferences from the knowns.
Precisely. This, again, I accept as an unusual scenario. It's very unlikely to happen again because nearly all of these cases, they're going to be witnesses of material events in a way which they weren't in this case for the reasons that we know. That's why, with respect...
It doesn't really matter whether it's unique. We've just got to find out whether the judge got it right.
Yeah.
Yes.
I mean, the unknowns that I've identified, of course, of the argument have been, why was he moved into the back seat? Why did Dean leave Aaron behind? How did Dean get the car started? And why did he drive towards Northridge? Are there any other?
The opposite
Are there any? Yes. Are there any other unknowns or unanswered questions which you say undermine the reliability of the inferences the judge drew from the knowns?
In my list of known unknowns, my Lord, I've given.
Okay. We've been here before.
I got to 14.
Okay,
yes.
14. All right. But
And we what we do know, if we're moving on to, can you deduce anything from these facts? The basic facts that there are. The basic facts also include the fact that Aaron is saying, fast asleep, passed out, both phrases he uses I accept. Both at the time they left him in the car to go to the club for a second time, to carry on for another hour's drinking, about which, of course, he would have known nothing. But when they come back, similarly, he's passed out. He gets into the back of the seat, gets out again, he's still passed out when he departs. And 25 minutes later, the judge finds, on the evidence, I don't quarrel with that, that is when the defendant is likely to have set off on his fateful last journey. So the last piece of evidence that this court has, and the trial judge had, as to this man's state, was that he was passed out. And everything thereafter, with respect, is conjecture. All sorts of things could happen, and all sorts of things might have happened.
The judge's inference is drawn not from the fact, from what happened immediately before they drove off, but from the fact that he got into the back seat.
Well,
and must have been therefore conscious to a degree at that point.
Well,
which is a finding which Mr. Kennedy says was open to him.
Well, obviously my submission is that it wasn't open to him because there's so little known about how he got into the back seat. What the judges assumed is that he was assisted by one person only, and that was the defendant. Now, that may not be right, but the evidence doesn't enable the judge to conclude that. It is merely one of a range of
Isn't a better challenge for you not to speculate about these unknown third parties, but to say that it's perfectly reasonable to assume that you can get somebody from the back seat to the front seat. Judge is entirely right, sorry, the front seat to the back seat, that he would have had to have got up and become for a short time at least semi-conscious and semi-cooperative. But if he then slumps back into the state he was in before, none of that reaches the necessary level of consciousness for his case.
Yes, I've also submitted that. I've also submitted that.
Yes.
Yes, I was.
That is your
dealing
point.
with
that is your point.
Yeah, I'm endeavouring to deal with Lord Justice Baker's point.
Yes, anyway, we understand very clearly what your case is,
Right.
on that, which I agree is the difficult area in the case. But
It is.
do you need to say anything more about that?
No, my lord. So the objective test. Move briefly on to that, if I may. The learned friend refers to the, maybe I put it too high when I say the interorum argument of what if the court were to allow drink to be taken into account in these circumstances such as arise in this case. In our respectful submission, that doesn't take the principle anywhere. The principle is the principle. The principle we respectfully submit that falls to be applied is the one which was articulated in McPherson, forgive me. And I won't repeat it, but your lordship knows that what's postulated in that case is the risk for which you are now, on a finding of contributory negligence, going to attribute blame to the claimant is a risk that he didn't foresee before he got drunk. He didn't foresee it in this case because you were going to go home by taxi, according to the charge. So he's in a shocking state by the time the risk is presented to him. That's why, as a matter of principle, it is not appropriate to apply my learned friend's version of a strict, inflexible, objective, reasonable man test, because it ignores the risk which is associated with the blameworthiness, which is that which gives rise to the finding of contributory negligence. And so it's all of a one. They're inextricably linked, one with the other. It's going to be, again, an unusual set of circumstances where that presentation of the risk happens so late in the day, as in this case. In the ordinary case, it happens very much earlier in the process. And that's why, ordinarily, an application of the objective test type my learned friend's talking about fits in very neatly with the state of affairs, where you say, well, if you go drinking with another man in a public house and you drink so much that you can't properly assess that he is not fit to drive, and you then make an election to get into his car with him at a time when you've just had too much to drink, and you're therefore not making the assessment you would make if you were sober, then the objective test applies perfectly harmoniously there, and perfectly appropriately. Similarly, as we have submitted in relation to Lord Justice, Mr. Justice Tasker Watkins, as he then was, if conversely you decide you're going to go on a pub crawl and the defendant is going to be your driver, and you both drink to yourself to be insensible, certainly the passenger has drunk himself to insensibility and he's put into the car by that driver. The reason why you can find that passenger guilty of contributory negligence is because when he was sober, he made a decision that he would. The agreement.
We have
would
got
be
that point.
Thank you. But that's not this case.
Just taking that to its extreme, if you're being fair to that person,
Yeah.
I make that agreement with you, I start drinking, but at that stage, I then become insensible through drink and haven't realised you're continuing to drink. Why is it fair on your analysis that I should lose 20%?
No, because the presentation of the risk that you were going to be driven by that person is because you've made that agreement in advance when you were sober.
I did, but I didn't realise he was going to get as drunk as he was, and it was just because I was drunk that I didn't appreciate that.
Well, that may be so, but that's where the element of recklessness comes in, to which Mr. Justice Tasker-Watkins referred. So if you've made your prior agreement, then you can't complain that you've lost your ability to make your judgment call later in the day. You've committed yourself to that course of action. That's the distinguishing feature. And if I postulate a different example, you've got somebody who's lying out cold outside the club, and two good Samaritans for this purpose decide to pick him up, give him a ride home, or take him away, and they've told where he lives. They put him in the car. One of those is
not as good as
unfit.
One of those is not a totally good Samaritan.
No, yes, that's why I said in quotes. They were trying to be helpful, but they weren't in the circumstances. Now, in that scenario, you couldn't say because he got himself so hopelessly drunk that he couldn't reach a decision at that stage, that he has to live with the consequences. So that's because there wouldn't be appreciation of the risk that gave rise to the liability and contributory negligence. And that's the distinction between
But that
Malone
person, in those circumstances, objectively wouldn't have been careless. Would they? That person would not have been careless in those circumstances.
Well, on Malone Friend's approach, it is, because he's allowed himself to get hopelessly drunk. And therefore he can't complain about his own drunkenness as a defence.
Well, it depends. Is your man in your hypothetical example conscious or not?
Well, he's in a position, one, if he's unconscious, that's one scenario. The other one is where he's in such a state that he's not able to take reasonable care for his own safety, which is what the test for contributory negligence is.
But you say that's Mr. Kennedy's case, but I don't think it is Mr. Kennedy's case, is it? Because the judge didn't decide it on the Owens and Brimmel scenario. That's, as you pointed this out, that's 154. He decided it entirely on the sequence of events once he'd been placed in the car. And in particular on what happened when, as the judge found, he became conscious after an hour.
Yeah.
So I don't think you can attribute, there's no respondent's notice on that. I didn't detect anything in Mr. Kennedy's argument seeking to revive that argument. I don't even know if that's quite how it was put below. But anyway, it's not how it's been put before us. So I'm not quite sure what argument of Mr. Kennedy's you're seeking to knock down.
The general one that the objective test applies across the board. That's all.
Yes, I see.
I'm dealing it in
So all these,
general way.
yes.
Yeah.
Well, I don't think Mr. Kennedy's case is that everybody who gets drunk is contributing negligence to anything that happens to them. I don't understand that to be Mr. Kennedy's. Smiling Delphic. I don't know if this is his case or not.
It's not my case.
I didn't think it was his case.
But it doesn't get away from the fact that the blameworthiness and the failure to take care for your own safety is the risk that has to be presented at a time when you're in a position to be able to make a decision about it. And if at that stage, because it hasn't been anticipated, you've got yourself hopelessly drunk, you should not be found guilty of contributory negligence thereafter. I mean, otherwise
you slightly overstated it by saying the judge made a finding that he would go back in a taxi. He just said it was quite possible.
Yes, my Lord, that's right. He said it's likely.
He said it's quite
possible. Quite possible. Forgive me if your Lordship's got the phrase. That's right. But the point is that the judge is accepting And it's further reinforcing the fact that there was no prior agreement between them. And secondly,
Okay, well, I think we probably explored this enough. It is an important area, but is there anything more you need to say on that aspect?
Lunton Khalifa, could I just make this one bold point in relation to it? Lunton Khalifa is a case which is not helpful to this court in our respect. Not helpful because it's a case where the conduct of the claimant was a cause of the accident. Now, there's no doubting the fact that when you're dealing with responsibility for causing an accident, as opposed to this case where he didn't do anything to cause this collision, then it's a purely objective test. So that
Okay, we have that point. Yeah.
Booth. My point on Booth. If you go to 376, please, my lord. Paragraph 6, you can see that what is being applied there is Mr. Justice Watkins' test. And similarly, Brignall and Kelly is then referred to, which is an
Those are not the
knowledge
passages.
test.
Those are not the passages to which we were taken. The ones you need to reply on, surely, are the ones boxed.
In the box.
Para 20.
Yes.
Primarily para 20. But also my lord referred, and Mr. Kennedy adopted it to the apparent acceptance of para 10. Objectivity.
Yes, but in paragraph 10, the distinguishing feature there in relation to Judge Curl's conclusions was there was a passenger who had agreed voluntarily to be driven by the defendant, which is why that has application in that scenario. If I go on to paragraph 20, which my learned friend referred to, again, what's being postulated here is a scenario where the claimant is making a voluntary election and a decision to accept a lift in those circumstances. And of course, that is what we respectfully submit in this case. This claimant was not in a position to do, given his condition.
Yeah.
Griffiths, tab 11242. It's the very end of this case that is of assistance. If I take you on to page 246, Lord. So the learned judge in this case, I accept, decided earlier on there wasn't a duty of care in this respect. He's going on to say, postulate, if he was wrong, what might the duty entail? So he says, halfway down the second paragraph, in the boxed area, in my judgment, such a duty would only be feasible if a breach would only arise in circumstances where it was apparent that the passenger, in the words of the Oldham J, in Underhill, quotes, had reached such a state of intoxication that he was incapable of taking care for his own safety. Next, third sentence further on. If there is a duty of the sort claimed, then in my judgment, it could only be breached in a clear and obvious case that is where the passenger plainly reached such a state of intoxication, he was clearly incapable of taking care for his own safety. And he goes on to look at the evidence in that case and say it didn't apply there in particular because they gave instructions as to their destination. Page 247. So I rely on this in this context, that it's indicating a level of responsibility on the part of the driver in relation to his passenger and his duty to take care of his passenger in circumstances such as prevail here. That's yet another reason why, according to the Australian authorities I took your lordship to, you have to look at the risk and when it arose and the state of the individual when it was. It's also material in my respectful submission on the question of apportionment as well, because it shows why there should be, in addition to a responsibility for the causes of the accident, an additional level of responsibility on the part of the driver because of his obligation to pay heed to a passenger who he could see was incapable of taking care for his own safety. So unless there are any particular further matters you wish me to address.
Not as far as I'm concerned.
No, thank you.
Well, obviously this is, as I've said, an important case for both parties, but certainly for your clients. I say, and we will need to take time to think about it carefully. We will obviously follow the usual procedure, whereby when we reach a decision, our judgments will be circulated to counsel in draft, so that they can agree the terms of any consequential order without the need for any further hearing. Also, please draw our attention to any typographical or other minor factual errors. The judgment will then be handed down probably under the new procedure, but it doesn't really make much difference because even if it was under the old procedure, no one need attend. Thank you very much indeed.
Thank you.
All rise. Ladies and gentlemen, I'll just end the live stream, so the last seconds delay.